Recording.
So we're going to start now with Chapter 6, Estates and Interests. In this chapter, we're going to identify the characteristics of estates and land. We're going to learn what an estate and land is. We're going to learn about the ownership category of estates. And we're going to describe the characteristics of encumbrances. We're going to learn what the word encumbrance means. We're going to learn about liens, easements, and encroachments, and so on. So let's start off with estate in land. Describes the amount and kind of interest that a person has in real property. Now, in your book on the first page, it says the amount and kind of ownership interest. We're going to cross out the word ownership. This particular chapter is only going over the first category of estates and land, which are freehold estates. There is another chapter that will go over less than freehold, which are leasehold estates. But this chapter, we're just going over the freehold estates. But the truest definition of estate in land describes the amount and kind of interest that a person has in real property. And there's two categories of estates in land. We have freehold estates, which is the category of ownership. And there's three types of freehold estates we're going to go over in this chapter. And there is the other category, which is less than freehold. It's called a leasehold estate. And there's four types of leasehold estates, which we'll go over in chapter 12 when we start talking about leases.
Right now we're on 7, correct?
6.
Oh, 6? Okay.
Yep. Chapter 6.
Okay, thank you.
Okay. So here we'll do the highlights and do that crossing out of the word ownership, like I just told you what to do, right? The amount and kind of ownership. We're just going to, they only have the word ownership here because this chapter is specifically talking about ownership. But the definition of an estate and land is the amount and kind of interest that a person has in real property. It doesn't necessarily have to be an ownership interest. Okay. And so if I read the first sentence here, it says, not all forms of ownership in real estate are equal. An owner may or may not be able to pass property on to their heirs. Sometimes ownership may exist only as long as the property is used for one specific purpose. In addition, other persons may possess certain interests or have legal claims or rights in one's real estate. So now we're going to start getting into nitty gritty. So we got those two categories of estates and land. Once again, freehold is the ownership category. Less than freehold, the leasehold is a leasehold estate, which, yes, it's when you're renting the property, you're leasing it. Let me know when you got all those notes taken care of over there.
I guess we set.
Okay. Everybody's all set there. And there's three types of freehold estates: fee simple, fee determinable, and a life estate. So let's highlight here freehold estates and then write the number 3 before that, because there are 3 types of freehold estates. And then we could just highlight straight down fee simple, fee determinable, and life estate. These first 2 categories of estates continue for an indefinite period of time, and they're inheritable by the ancestors of the owner. The third estate ends on the death of the person whose life it is based. So, a leasehold estate. Let's first talk about these leasehold estates really quick before we get into the freehold ones. We're just going to give a quick rundown. We're not going to go deep into this. Leasehold estates involve leases and tenants. A lease signifies a tenant's right to occupy an owner's property for a limited period of time as defined in a lease. Leases involve tenants who are the lessee. They're the owners are known as the lessor. A lease is personal property, which is an intangible or incorporeal asset. It's not considered real property ownership. So therefore, if you possess a lease is considered personal property, not real property. So a lease describes the tenant's rights to occupy someone else's property for a limited period of time as defined in a lease, as well as the terms, the length of time, what exactly is being leased, and any limitations on the estate. So leaseholds, let's highlight, involve tenants. You can see what I got written here. Let's highlight that on page 104. Okay. Now, there are 3 types of freehold estates. They are fee simple estates, which goes by 3 different names. Fee simple, fee simple, or fee simple absolute. Okay. They all describe this first type of estate. Fee simple, and fee simple absolute are the same thing. They are the highest forms of ownership recognized by law. It is ownership forever without restriction. So write that next to the title, ownership forever without restrictions. And then highlight is the highest, fee simple is the highest type of interest in real estate recognized by law. You have unrestricted ownership of that property forever. You could even dictate who gets it after you die.
You said highest form of interest? Oh, okay.
Yeah, it's the highest form of ownership interest in real property recognized by law. It's unrestricted it's ownership forever without restrictions. You own it forever. So when you die, you could dictate who gets it. Well, do you need to give it to somebody when you die? Well, if you don't, what happens to it?
The
If somebody
state
doesn't,
government.
It's cheat.
yeah, it is cheats to the state. You know, they want to make sure somebody's going to be paying the taxes on it. Can you leave the property to your cat or your dog? Sure, you can, but they're not going to be paying the taxes on it, though, are they? Who's going to be responsible for that property? Well, I mean, take a look. What was that? Imelda Marcus? Imelda Marcus, she did that. Remember that heiress? She left everything to her dog. She left her fortune to her dog. Uh, of course, she had to name somebody as the carekeeper for the dog because the dog can't go out buying its own food and taking care of her her estate, her property and everything. So she left everything to her dog, and she named the keeper to take care of the dog. Now, who gets it after the dog? I don't know. I mean, it's not like a dog writes a will. It's a curious thing to Google if you want to look up that fact. I never bothered. I wasn't that interested. But if you guys want to do a little research on that, you could maybe have AI do a little search for you. It's interesting. You remember that Imelda Marcus? Uh, yeah.
Maybe it was escheated after the dog.
I don't know. She had that, or maybe she wrote a life estate. She said that the dog gets it for as long as he's alive, but on his death, then it goes to someone else. You could do that too. Oh, but leaving it to a dog, that's funny, right? Anyway, the next one is fee determinable estate. Right next to the title, ownership forever based on a restriction called a restrictive covenant. Okay, so fee determinable estates are ownership forever, but that ownership is based on a restriction. You own that property forever, but the ownership is based on a restriction. As long as you do not violate the restriction that you agreed to when you bought the property, you're the owner. Just don't violate the restriction that they gave you. Like if Shell gas station sells you one of their properties and they put a restriction in the deed that the property can no longer be used as a gas station unless it's a Shell gas station. Okay. As long as you don't violate the terms of that restriction that were placed in the deed, you're the owner of the property forever. You violate the terms of that restriction, they could take you back to court to take back the ownership of the property because you violated the terms of the sale.
Who can take back?
The person who placed the restriction in the deed to begin with. So if you bought a property from Shell gas station and they told you can't use it as a gas station again unless it's a Shell gas station, and then you turn around and put an X on there, they could take you to court to regain ownership of the property because you violated the simple terms that you agreed to when you bought the property.
What if they die? I mean, they're no more.
What if the person who put the restriction in the deed dies? Who inherits the rights of the person who died? That person would be able to enforce those restrictions as well. Okay. Now, restrictions placed in deeds are called restrictive covenants. Okay. A covenant is a legal promise. These are restrictive legal promises that you made in the deed. So it's called a restrictive covenant. These are restrictions placed in deeds. They're called restrictive covenants. Now, you're the owner of the property as long as you don't violate the terms of the sale. So highlight fee determinable, also known as a conditional or defeasible fee. Yes, this one goes by three names too. Fee determinable, also known as a conditional fee because it's based on a condition, as long as you don't violate the terms of the conditions, right? Also known as a defeasible fee. So is an estate and land that can terminate on the occurrence or non-occurrence of a specified event. So for an example, as they give you here in the book, an owner conveys their title to 1,000 acres of land that they own to the Open Space Foundation, so long as it is maintained as a wildlife preserve. But 5 years later, that foundation decides they're going to build their world corporate headquarters on this land. They basically violated the restriction. So the title, the ownership to the land, reverts back to the owner who gave them the land or sold them the property with the restriction. This future interest is called the possibility of reverter. It's possible that the ownership interest can revert back to the previous owner who placed a restriction in the land. If you didn't violate it, there's nothing to worry about. Violate the restriction, the ownership can revert back to the previous owner. And check this out. What if you buy that property with a restriction and then you sell that property to someone else? What is that third person getting? They're getting the real estate plus all the rights that you possess in that real estate. And your rights were already restricted at some degree because there was a restriction placed in the deed. You can't create new rights to the person you're selling the property for. You can only pass on the rights that you have. And if your rights are already restricted, that's all that you could pass on with the land, right? So if you have a restriction that this property needs to be used as a wildlife preserve, and then you turn around and sell it to someone else, they need to follow that restriction as well. Restrictive covenants run with the land. Unless the person who put the restriction in the deed puts an expiration date on it. We call that a sunset clause. That by a certain date or by the certain happening of an event, the restriction would go away. If they didn't put such a sunset clause in the deed, then it's there forever. That restriction runs with the land, meaning that it passes on from one owner to the next.
But why will person B will buy the land with the restrictive covenants rule? Can we take that example where the mineral rights, the Texas lady took the mineral rights? Is that the restrictive covenant? No.
Well, if I sold you my property and I put a restriction here, let's put a wacky restriction in there. Okay. Let's just say I'm selling you my property and I got a problem with alcohol because my wife and child got killed in a car accident by a drunk driver. Okay, so now I'm that's always on my mind. So I put a restriction in the deed. I'm going to sell you my property as long as no alcoholic beverages are ever on or consumed in that property. It sounds like a wacky thing, but is there anything illegal about that if you agree to it? No. But if you agree to that term and you try to sell that property later on down the road, you're selling the property with those restrictions to future owners as well. So can that affect the value and desirability of the property that you now own? Yeah, because somebody may like to get their drink on. I like to have a beer after work, sit up and maybe have the boys over, watch a football game, have a few brewskis, right? Well, according to your deed, you can't do that. Who's going to know? Let's say the cops are called to a disturbance with a bunch of drunken adults having an argument over something. Now it's a public record. If the person who put that restriction in a deed finds out about it, they could take you to court and take the property back without paying you a penny because you violated the terms of the sale. So don't violate the terms of the sale. There's no problems. I just gave you a really wacky restriction. Okay. Now, so it passes on from one owner to the next.
So then it's a burden for the new owner to follow those rules.
It is. It is.
So do people buy with this covenant?
It's not that common in residential property. It's more common in commercial.
Okay.
Okay. For obvious reasons, like the Shell gas station reason I gave you. They don't want the competition moving into one of their old properties, so they put a restriction in there that the property can't be used as a gas station again. This is why a lot of times today, if you look around, you could see old gas stations all of a sudden, they're convenience stores, or they become like an office building for an attorney or a chiropractor. They're not being used as a gas station anymore with an auto shop. Okay. The auto shop would still be fine. They can still have the auto shop there, but often those old gas stations, people buy them up and they turn them into like convenience stores or something. I actually tried buying a few of them, but somebody jumped on it that had the cash to buy it. They got them a really cheap price. Gas stations were they just looked to sell them, so they got them for like 200 grand. But somebody had 200 grand cash, and I didn't have 200 grand cash laying around to spend at the time, so they bought the property for 200 grand cash, and then they turned it into a convenience store. Okay, that
So
happens a
that
lot.
example which you gave for Texas girl who had those mineral rights
Uh
is
huh.
not the right example for restrictive covenants. That's rights,
Well,
right?
well, we're hmm. No,
No.
no, because you don't own the land. You only have a right to the minerals in it.
Yes. Okay.
Okay. Now, that future possibility of the ownership reverting back if you violate the terms of the sale is called the possibility of reverter. Now, the property would revert back to the person who put the restriction in the deed. However, that owner, when they sell you the property and they base it on a restriction, they could also say that, hey, wait a minute, in the event you violate the restriction, instead of it coming back to me or my heirs if I'm no longer around, I want this other third party to get the property if you violate the terms. That person is called a remainder man. So you could add that term to your definition list too. What is a remainder man? It's a third party named in an instrument, a document, to be a beneficiary. So that's what a remainder man is. A third party named in an instrument. Instrument's a fancy word for a document to be a beneficiary.
So after the dog, if any third person name was mentioned in the will, that was remainder man, right?
Correct. Correct.
Okay.
Mm-hmm. Now, a life estate is ownership, but it's based on a life. So a life estate is limited to the life of a person, a specific person. The owner of a normal life estate does not have the right to pass ownership to their heirs because a life estate ends with the death of the owner who was granted the life estate. It's based on your life.
These
If I,
are all
if I,
deeds, correct?
I'm sorry.
These are all different kinds of deeds.
No, these are different types of ownership. A deed is a document used to transfer ownership. We're going to go over different types of deeds in chapter 19. Okay. The,
But what is this, for example, like I know what it is, but when would I use these? Like, would I write it on a paper for
you wouldn't do
someone?
it. You wouldn't do anything. This is legal stuff. An attorney would do this.
Oh, okay.
Okay. And why do we need to know about it? Well, because you go in for a listing, you ask the owner if they have a copy of their original deed and their original deed and their uh, survey of their property. And we read their deed, look over the deed. You could see who all the owners are who bought the property. So if you're only meeting with one person, but it shows that there was three owners, where are the other two people? You need to get signatures from two other people, unless they could prove that they died and they left it to you, you know? Um, so we want to look at these documents to get a little information about them. And if we see that it says fee simple ownership, or if it says fee determinable, conditional, or defeasible fee, uh-oh, there's a restriction in the deed. We need to read a little bit further, see what that restriction is and what the rules of it are. Okay. That's why it's good
Thank you.
to understand this. Now, do most agents ever do that? No. They just go in with their listing papers, here, sign there, sign there. They don't even check IDs most of the time. You should. I already told you why. And I told you to check tax records before you ever go over to the house so that you could see who the current owners are listed as. But it's not a bad idea to ask the owner to prepare these documents for you too, so you could get a copy of the deed and the survey. Now, they don't need to make a photocopy for you because you could get something, an application that is free. You could download a document called Adobe Scan. I'm sorry, an application called Adobe Scan. It's a free, I'm sure there's other ones out there too, but this one's pretty good. You can use the camera on your cell phone, which is usually high quality cameras these days, right? And you just hover it level over a document with good lighting. Try not to get any shadows cast on it. And it'll automatically find the edges of the document, and it'll scan it into a PDF or an image. I like to scan to PDF because PDF is more flexible and it's easier to print than images. Sometimes images are hard to print. If they're too big of a resolution, it'll print on several pages. Too small of a resolution, and it'll look like you need a microscope to see it. But an Adobe PDF document, it'll print properly. Okay. And now you could print out or make this document available to people online in the MLS. You could upload it as a document they could download, and they could see the survey, they could see the original deed. But you don't want to post original deeds on there. Maybe a survey is fine. Okay. So life estate is based on the person whose life the estate is measured against. So we're just going to make it simple, and right next to life estate is ownership based on a life. And that life is usually based on the person's life it is given to. When they die, the estate reverts back to the previous owner or their heirs or a remainder man if named. Right? Now, how about this? There's also another spin on the take of a life estate, which we're going to learn about as well. Instead of me giving you a life estate, which is then based on your life, you have the full ownership rights of anybody. You could sell the property, lease it, give it away. You just can't destroy the value of the estate. So you need to pay taxes on it, maintain it, all right? So if you have a life estate, that's the only rule. You can't destroy the value of the estate. You have to maintain it. So if I give you a life estate, I'm giving you ownership of my property. You have all the ownership rights of anybody. You could sell it, lease it, or give it away. If you lease it, yeah, you can make money. If you sell it, what is the person getting that you're selling it to? They're getting all the ownership of the property as long as you're alive. Because it's based on your life. I gave you my property based on your life, not theirs. I don't know who this person is. So if you sell that property to someone else, they're buying the property and they'll be the owner for as long as you're alive. It's based on your life. You can't create new restrictions or new rules, or you create restrictions, but you can't create new rights for people. So if I gave you ownership of a property, it's based on your life. You can't extend it by saying, well, it's based on someone else's life now, or pass on to, oh, well, it's based on your life. You know, it's based on the life of the person who the estate was given to. Okay. So there's also another twist to this. There's something called a life estate por otra vie. Now, that's a Latin term. I know it's pronounced and it sounds the same in French, but the spelling is differently in Latin to French, but it's pronounced and it means the same thing. Por otra vie means for the life of another. So a life estate por otra vie means I'm giving you a life estate not based on your life, but based on someone else's. Okay? I guess you could think up scenarios where that would make sense for people to do that. But let's move on. Everybody got these highlights in these notes in their book? Can I change the slide, or anybody still writing?
I got it.
Okie doke. So let's do a little recap here. We have fee simple, also known as fee simple, or fee simple absolute. It's the highest form of ownership, the most complete form of ownership recognized by law. It's ownership forever without restriction. Then we have the fee determinable estate that also goes by defeasible and conditional fee. It's ownership forever, but based on a restriction called a restrictive covenant, which can only be added to deeds by private parties. Governments cannot place restrictions in deeds. You need to know that. Only private parties can place restrictions in deeds. The owner of the property places the restriction on the deed when they sell it. Okay. Government does not place restrictions in deeds. Government has their own powers on how they could limit how you use your property through zoning ordinances, right? So if the restriction is violated, ownership would revert back to the person who placed the restriction in the deed. This is called the possibility of reverter, or to a remainder man, which is a third party named in an instrument to be a beneficiary. Now, this restrictive condition runs with the land. It passes on to the next owner and can only be removed by the person who added the restriction to the deed, or their heirs, or by a court. But a court is not likely to remove the restriction in most circumstances. The only time they would is really if it was an illegal restriction or overly restrictive. Like if you left the property to a family member and you said that they cannot sell the property unless it was to another family member. You know, look, there's other ways that you could create that and keep it in the family by creating a family foundation that the majority of the family members would have to agree to sell the property. And that would, but the intent of the foundation was to benefit the family and to keep the property ownership in this type of conservativeship of some sort, you know. But it's too restrictive of a requirement. Or if it was an illegal restriction, like a discriminatory restriction, saying you can't sell the property to a person of color or a person of this religion or what have you. That's an illegal restriction because it's discriminatory. Then a court could remove it. Now, the life estate is ownership, and it's based on the life of the person against whose life it's measured. They cannot leave by will because when you die, the property reverts back to the person who gave it to you, their heirs, or a remainder man. So they can't leave the property by will, and they have all the rights of ownership to sell, lease, mortgage, give away the property, but they cannot destroy the estate's value. You got to pay the taxes on the property so it can't get taken away or sold at an auction. Upon their death, ownership reverts back to the person who gave the life estate or to a remainder man or heirs. One famous arrangement of a life estate was Hugh Hefner. Anybody remember that guy? He was the owner of Playboy magazine. You may have heard of it. Playboy magazine. Now, Hugh Hefner's been dead for a couple of years already. But when he sold his property, a lot of people don't know he sold the Playboy Mansion in Beverly Hills when he was still alive and living there. Why did he do that? He needed the money. What? Hugh Hefner? Playboy magazine needed money? Yep. It ain't cheap living a Playboy lifestyle.
Victor, I'm not able to grasp this life estate thing. It is based on life until the person is alive.
Yes. So I give you my property. I give you a life estate, my property. I'm giving you my house.
Okay.
So you have full ownership rights of my house for as long as you're alive.
I am alive.
Yes, because I'm giving you a life estate. It's based on your life.
Okay.
Okay. So when you die, you can't leave it to your kids or anybody else in your will,
Okay.
because I only gave you ownership for as long as you're alive, not after you die. After you die, it comes back to me. And if I'm dead, it goes to my heirs, not yours.
Got it. Okay.
Okay?
Thanks. Yeah.
You're welcome. So Hugh Hefner is a famous case where example where he did a life estate. He sold the Playboy Mansion while he was still alive because he needed the money. You know, hey, magazines, with the invention of the internet, everybody can get their porn for free online, right? They don't need to be buying a magazine no more. But he had the Playboy channel, the Playboy website. He still got money coming in, but a lot of that was made part of a Playboy became a corporation that was publicly traded too. So it became part of that. But he still had like rights to like the famous Playboy bunny logo and things of that he licensed out. He had the Playboy websites. He was still getting money. He was still getting paid, but the lifestyle he leads, where you're constantly having these huge parties, all the bunnies living there, you know, the women that were living there, taking care of them, having ex-wives that you give them as a settlement, you buy them a yachts that they live on, you know, yeah, a yacht is a big boat. And what is a boat? Anybody who ever owned a boat, what does a boat stand for? You know, the letters in boat, you know, BOAT, boat. Bust out another 1,000. Because anytime something breaks, it's always in the thousands. Nothing is cheap with ownership
Seriously?
of boats. I'm dead serious.
Okay.
That's a saying that goes on with boat
Okay.
owners. You know? Boat stands for bust out another 1,000, because anytime something breaks, you're spending at least $1,000 to fix it. You know, boat ownership's expensive. You know, so on a big boat like a yacht, you know, listen. You need a whole crew. You need a captain and all those other people. You need a whole crew of people to maintain a yacht with salaries that you're paying. So, I mean, Hugh Hefner, even though he gave that as a settlement for his ex-wife, one of the older Playboy bunnies, hey, it's still, that's a lot of money. So then as times changed, he retired. He was still there and the spokesman of Playboy magazine, but he put his daughter in place to run the Playboy. So she ran it for quite a few years, very successfully still. But she wanted to move out of Playboy and do something else. Okay. She was a successful businesswoman. She wanted to do something else. So Hugh Hefner put his son in charge of Playboy. Um, Now they live in California. California is extremely liberal. His son was like one of the new modern liberals that are like, you're so liberal, your brains fall out. You know, he's that kind of a guy. So his son, he put in charge of Playboy. And uh, his idea was, I'm going to have fun with it. What I'm going to do is I'm going to surprise our entire subscribing base of people who pay for subscriptions to our magazine. And I'm going to have a little fun with it. I'm going to make the first transgender centerfold. As you could imagine, the people who subscribe to Playboy magazine to see nude women are not expecting to see a new woman. You know, there's some extra parts there. So people were outraged. They canceled their subscriptions. Playboy just went down tubes after that with this guy's running of it. So he was losing money hand over fist. So Hugh Hefner decided he was going to sell the Playboy Mansion. I mean, it was a prime space in Beverly Hills. So he sold it to a billionaire neighbor of his. He put it on the market. A neighbor of his, which was a billionaire, decided that he would buy that property. It was estimated that it would sell for around, I think he was asking for 200 million, but it was estimated it would sell for more along the lines of $100 million, which it sold for around that. And the Playboy Mansion was in a decrepit condition, falling apart, constant parties since it was created in the 60s or whenever it was that he built it. Didn't maintain it. He had those little He had those 3 lap dogs that were always with him. If you guys remember seeing him, he always had one of those furry little lap dogs with him. They weren't trained. The bunnies said, the Playboy bunnies, they were like, yeah, the dogs aren't trained. They crap and they pee anywhere. So you could imagine how the place smelled. You know, people spilling drinks, the dogs crapping and peeing everywhere. The carpets haven't been changed since the 60s or 70s. You know, the place wasn't updated. You know, the roof was falling apart. The place was leaky. It was a mess. It looked nice on the outside, but it was, if you lived there, it was not so good. It needed massive makeover. But anyway, so here is the story. I'm going to click on it and show it to you. Look at that. Playboy mansion for sale with one life tenant. So it was a 29 room, 6 bedroom Beverly Hills mansion in decrepit condition. Playboy Enterprises hopes to sell it north of 200 million. Plus, the buyer will have to grapple with another huge catch. According to TMZ, they said they'll have to grant the 89-year-old Hefner a life estate, which means that he can continue living there till death departs him from his beloved bachelor pad. So imagine this: buying a mansion for $200 million, and you can't move in it until the current owner dies, because you buy it from them and then you have to give them back a life estate. So Hugh Hefner was allowed to live there until the day he died. But it was a lucky gamble for the neighbor owner, because he bought it for $100 million, gave Hugh Hefner a life estate back. Hugh Hefner was already 89 years old. At the time, where was it? The life expectancy of an 89-year-old, or the life expectancy of most males in the United States, was only about, let me see. Where is it? Oh, the average life expectancy of a male's life in the United States is 84.3. So Hugh was already, on borrowed time there at 89 years of age. They ended up selling the property around $100 million. And the new owner bought it, gave Hugh Hefner back a life estate. Hugh Hefner lived for 1 year and died the next year. So it was a short life estate. Now, when he bought it, there was a further agreement that he can't tear down the mansion. It has very historical significance. You had presidents and dignitaries and Hollywood celebrities, Marilyn Monroe and JFK. All these people were at that place. Basketball, football stars, you name it, right? So he couldn't tear it down. So instead, he had to renovate it. So this young guy, the billionaire that bought the Playboy Mansion, agreed to those terms. Now you may be thinking, how does this guy get all this money? Look how young he is. Doesn't he look young? Yeah, he's about 40 years old. His name was Darren Metropoulos. Okay. He is, where did he get his millions or billions from? Owning brands. He was taught that. Him and his brother are both filthy rich, just like the father, who taught them how to buy and own brands of things. So like food brands, like Nabisco, like Pabst Blue Ribbon beer, like things of that nature. He's an owner of brands, different brands. And so he's thinking filthy rich. There we go. Let's go up here. So now, after he bought it, he decided to renovate the Playboy Mansion, the billionaire owner. He spent $10 million in renovating the mansion. It took 5 years to do it. Here's the lovely Playboy Mansion with the infamous grotto underneath there. Got tennis courts and all kinds of stuff. I'm not sure if this is the renovated one. Yeah, this is the renovated new house, where that looks really nice. Okay. There was Hugh Hefner when he was alive, always in his silk underwear, in his silk robe. in the Playboy Mansion. Doesn't look that bad from the pictures, but you should see some of the other rooms. Uh, there's the tennis courts. It's a big place. There's the infamous grotto where some things happened where a lot of people got sick there one time with Legionnaire's disease and all kinds of other, debauchery that was going on there. Playboy bunnies on the front lawn. All right. Anyway, okay, I thought that this page had all the before and after photos, but that was another page. But that's all we need to see right there. It's good enough. So imagine that, for sale with owner. That used to be the title of the picture on that page. When it would come up, with for sale with owner. Interesting sign to have put up there. All right. So once again,
I have a question. I have a question. So he sold his property, he sold his mansion to his neighbor. What did he get from that? I mean, till death he was there. Was he maintaining that life, that mansion, the neighbor?
no, because
Then what's the point of selling?
the neighbor bought it. The neighbor didn't sell. The neighbor bought it from Hugh Hefner. He bought it for $100 million from Hugh Hefner, but had on the condition that he gave back a life estate to Hugh Hefner so he could live there for the rest of his life. Hugh Hefner was already 89 years old. The guy was probably thinking, how much longer is he going to live? 2, 3 years, it's not going to, if he lives to be 100, it's 10, 11, 12 years, but, he's 89 years old. The average life expectancy is 84 and a half. He's already living on borrowed time. So it was a good gamble for him to take. And Hugh Hefner ended up living only one more year. So
his
on
that pension would go to his heirs, no?
No. Hugh Hefner sold the property to his neighbor. His neighbor gave Hugh Hefner back the ownership in a form of a life estate. So when Hugh Hefner dies, the property goes back to the guy who bought the estate. Okay, here. Let's use you and me as an example, okay? All right. Say you sell me your house, okay?
Okay.
And I buy the house from you.
Okay.
But you sell it on a condition that I have to give you back a life estate. Okay? So you sold me the house, I paid you for the house, but I had to give you ownership back. I gave you a life estate back. So when you die, that's when I can actually get the ownership back where I could actually possess it.
Yeah, I got that. But why did he do that? His property could go to his heirs.
Because he needed the money.
Okay.
Hugh Hefner's son mismanaged the hell out of it, putting transgender centerfolds in a nudie magazine where guys that were subscribing to it were expecting to see women. I mean, as it is, magazine sales are down with the invention of the internet. And contrary to popular belief, everybody did not buy Playboy magazine for the articles.
Got it.
So I mean, his wealth was going downhill, especially with having constant parties, 24-hour, 24/7, 365 days a year, chefs on call to make his peanut butter jelly sandwiches whenever he wanted or whatever, and for feeding his guests. It costs money. It's expensive to live that lifestyle, and so especially when his income was dropping, he needed the money. So he figured, selling the mansion and getting back a life estate, $100 million. Yeah, I could get by for the rest of my life on $100 million. I think I could do that. So that's what he did. And it was a good gamble. And whatever was left over, his kids get as if he left it to them in a will. The son seems kind of dopey, so I would suspect he's probably already broke. But that's the way that a cookie crumbles, right? All right. So fee simple, just to recap, also known as fee simple, absolute. Highest form of ownership interest recognized by law. It's unrestricted ownership forever. The holder is entitled to all the rights in the property, and the owner's death, on the owner's death, the estate passes to his heirs or devisees that he may name in a will. Okay. Fee determinable, also known as a defeasible fee or conditional fee, is ownership forever, but it's based on a restriction. If the restriction is violated, the ownership reverts back to the person who placed the restriction in the deed. This is called the possibility of reverter. Or it would go back to a remainder man, a third party named to be the beneficiary.
So we can say that all the residential properties mostly are fee simple?
Correct.
Yes. Okay.
The majority, not
Majority.
all.
Yeah. Yeah.
Majority.
Okay. Understood. Yeah. Thanks.
I mean, they could have some sorts of restrictions, but most people aren't that savvy to know even about putting restrictions. Have you ever heard of this before? Putting restrictions in deeds when you sell a property? Most people think that, hey, you either own it or you don't. I can't sell it to you and then tell you what you could do with the property, but you can if you know the law, if you know the rules. Okay. Attorneys know about this stuff, real estate agents know about this stuff, but most of the public does not.
And quite frankly, determinable, it runs forever until the main person cancels it.
If they do. Yes. So yeah, it's an estate that can terminate on the occurrence or non-occurrence of a specified event, some sort of a restriction called a restrictive covenant. And only private parties can place restrictions in deeds. Governments cannot do that. They've got their own powers for zoning, for example. Okay. Any restriction placed in the deed runs with the land. It passes on from one owner to the next. It cannot be removed by future owners. Only by the person who placed the restriction in the deed or their heirs, or in an unlikely event, a court. Courts are not likely to go against a property owner's wishes unless they're discriminatory or illegal in some way. So a life estate, it's limited to the life of the person it is given to. Ownership would revert back to the person who granted the life estate or to their heirs, devisees, or a remainder man. The life estate can be tied to the life of a third party. This is known as a life estate per altra vie. That means for the life of another. The holder of a life estate has true ownership of real property with all the rights and benefits, but only for their life. This is why you can't leave it to your kids. If you got a life estate, you can't leave it to your kids or heirs or anybody you name in your will, because you lose ownership when you die. You can't therefore assign it to someone else after you die. So life interest may be sold, leased, mortgaged, or given away while you're still alive, but it will end on the death of the person against whose life the estate is measured. So it cannot be left in a will to devisees or heirs. And we got that, once again, that famous Playboy one. Let me see, is this the link?
So remainder man and per altra vie are similar?
No. Per altra vie means for the life of another. Remainder man is a third party named in the instrument to be a beneficiary. So if I give you a life estate that's based on someone else's life, when they die, you lose the ownership. A regular life estate is based on your life. If I gave you a life estate, it's based on your life. When you die, you lose the ownership. It comes back to me. So you can't leave it in a will to somebody. If I give you a life estate per altra vie, I give you ownership of my property based on someone else's life other than you. That for the life of another. Okay. So, I mean, you could think up a scenario. Maybe you have a nursing history, right? You got some nursing experience. So I'm going to give you a life estate. I'm giving you my property. You're going to be the owner of my property, but there's a catch. There's a hitch. You have to live with my aging parent and take care of them for as long as they're alive. You can keep the ownership of the property. When they die, it comes back to me. So the agreement is that she has to live there in the house. I don't want her put in a nursing home. This is the whole idea of me giving you the house. You take care of her. She still gets around on her own pretty good. You don't have to be wiping her butt just yet. you know, but so you're the owner as long as my parents are alive. But when they die, then you lose the property. It comes back to me. Okay, that's one example where it could be used. All right, so I want you guys to highlight that on page 105. Life estate por otra vida, for another's life. The holder of a life estate has true ownership of real property. Okay, you could sell it, lease it, give it away, just can't destroy its value. So do all these highlights on page 105. I think this is on 104. Mm-hmm. Just say the word when you got it. See, most of this class is terms and definitions, some math, some laws, but there's some concepts too. Okay, like this. The concepts of ownership.
All
Now,
set.
this is estates and land that we're talking about. It's what exactly are you getting and what can you do with it? Okay, that's what an estate and land is talking about. What exactly are you getting and what can you do with it? After this, we're going to talk about different forms of ownership when you have more than one owner, when you have one or more owners. We're going to go over that in the next chapter. So this chapter is talking about estates and land. The next chapter is going to talk about ownership by one or more people. Okay. So what is a reversionary interest? The remainder man. Well, you have the grantor. They give you the title, the ownership to their property as a life tenant. They give you a life estate. When you die, the property reverts back to the grantor. So if the grantor's dead, it would go to their heirs or devisees or a remainder man if named. There's another way of saying that. Grantor gives the title to a life tenant. The life tenant dies. They could assign it to a remainder man, heirs or devisees. Okay. Dower and courtesy are ancient rights that a spouse has in their spouse's property. Dower is the wife's interest in her husband's estate upon their death. Oh, you know what? Let's just do this slide and then we'll be done for the day here, guys. We're already out of time. So, dower is the wife's interest in her husband's estate upon his death. Courtesy is the husband's interest in the wife's estate upon her death. And New Jersey abolished the creation of any new dower or courtesy rights as of May 28, 1980. And after that, they instead now give both husband and wife the joint possession of the property that's their primary marital residence. Property acquired before this date gives the surviving spouse a life estate in all the real estate owned by the deceased person, no matter what other provisions were made for in the will. They're entitled to half. In New Jersey, children may be disinherited, so be good to your parents. No, don't be good to your parents for that reason. Be good because you love them, right? But the surviving spouse is entitled to at least 1/3 of the estate for property acquired after May 28th, 1980. And the determination of the augmented estate is a complex calculation. If the required minimum is not left to the surviving spouse, the courts may grant 1/3 the estate to them by something called the right of election. The right of election is reserved only for a surviving spouse if their deceased spouse did not leave them the required minimum in their will. Here's a little tip. To remember which is the wife's right and which is the husband's, dower begins with a doe, and a doe is a deer, female deer. That's the wife's right. And courtesy, because men should be courteous to women. That's the husband's right. Okay. And we'll leave off there. Oh, this is the highlighted stuff. You guys, if you want to highlight it, put a circle around that on page 105 and 106. We could finish up with the dower and courtesy stuff. And we will stop right here for the day and continue chapter 6 tomorrow.